that's that. I want to go ahead and welcome our guest, Cynthia Flynn from Hackler Flynn Law Firm. Cindy is one of our EOLA members, as well as, actually both her and her husband are both EOLA members. And she runs a women-owned law firm here in California. And her focus is in employment law. And I thought with everything going on today in our worlds with COVID and PPPs and getting loans and all of that, that it would be really great to be able to have kind of a legal perspective on the situation. Hackler Flynn's expertise is in employment law and contracts and then lawsuits. And I know that, Cindy's been really fabulous in terms of just always being available to answer questions. So I thought that if we could have her here on a broader scale where she could answer the questions of other EOers from elsewhere, it would be great. Also on the call, we have Brooke Lively from the Fort Worth chapter, and Brooke's expertise is on PPP and SBA loans and so forth. So if a question comes up that is not necessarily employment related, we do have Brooke's expertise also on the call that Cindy can refer to as needed. And other than that, Cindy, I'm going to just pass it on to you to take us through this. Thank you so much for joining us.
All right, thank you so much for having me. And Brooke, I'm so glad you're here to answer any of those more technical loan related questions, because I've been getting a lot. And so to give you guys some background, my parents ran a printing company in the 80s. And as a kid, I got to go in there and help file paperwork and fold brochures and organize the stationery. And I got to see firsthand what it was like to run a business. And what I think is even more important, what it was like to have employees. And over the years of my parents running this printing business, they came up against some really difficult employment challenges. And ultimately, my parents ended in bankruptcy and divorce. So I just knew early on I wanted to be an employment lawyer, protecting and defending business owners, or who I think are doing the best job they can keeping people employed. And so when we look at reopening your business after COVID-19, I wanted to just give out as much information as I can to keep our business owners protected out there. And over the last 4 or 5 weeks, since all of this has come down, we've had probably 6 clients come to us with demand letters from former employees that they've let go of, demanding money. So it's important that even in times of a pandemic like this, we do everything we can to protect ourselves. So with that being said, I do have a disclaimer because I am an attorney. I am sorry, guys, but content on this webinar should not be considered legal advice and is for informational purposes only. Communications made through this webinar and or participating in the webinar do not create an attorney-client relationship. Although we're happy to have you as a client and create that relationship, nothing on this webinar does that. And so we're not responsible for any content that may be accessed from third-party resources or linked to this. So with that being said,
here's a dollar.
Oh,
here's
yeah.
a dollar. Now
There you go. There you go, Philip.
Couldn't help
Yes.
myself.
So for today's topics, a quick overview of the Paycheck Protection Loan Program, how to safely bring back the workforce, new hires, independent contractors, and versus employees in California, essentially the ABCs of AB5, and then working remotely. And Brooke, at any point, feel free to just jump in with your thoughts and advice on it. So as the coronavirus outbreak continues to impact markets and industries in the United States and around the world, businesses are now confronting significant and unique challenges, right? Successful navigation of these challenges will require thoughtful and comprehensive planning. The Coronavirus Aid, Relief and Economic Securities Act, known as CARES, amends numerous provisions of the federal tax law affecting both businesses and individuals. Many of the changes aim to help taxpayers conserve or generate cash either prospectively or by amending prior years. So on March 25th, 2020, the Senate unanimously passed 96-0 the CARES Act, right? The Coronavirus Aid, Relief, and Economic Security Act. And the CARES Act provides $2.2 trillion in stimulus to individuals, businesses, and hospitals in response to the economic distress caused by COVID-19, the pandemic. On March 27th, the House passed it, and then, of course, Trump signed it into law that day. So this provides stimulus for individuals, businesses, and hospitals in response to the economic impact caused by COVID. Part of the CARES Act includes a loan program for small businesses. These loans can be forgiven through a process that incentivizes companies to retain employees. And for today, I really just wanted to focus on the PPP loan. So the Paycheck Protection Loan Program, at a price tag of now $666 billion. It was originally the $350 billion, and then additional funding came into effect April 24th of this year with an additional $310 billion. And the period covered is from February 15th, 2020 through June 30th, 2020. And this greatly expands SBA loan eligibility. The loan program allows businesses suffering due to the coronavirus outbreak to borrow money for a variety of qualified costs related to employee compensation and benefits. And what those qualified costs look like are payroll, continuation of healthcare benefits, employee compensation, capped at the $100,000, mortgage interest obligations, rent, utilities, and interest on debt incurred before the period. So payroll costs are defined as wages, commissions, salary, or similar compensation to an employee, payment of a cash tip or equivalent, payment for vacation, parental, family, medical, or sick leave, allowance for dismissal or separation, payment for group health care benefits, including premiums, payment of any retirement benefits, and payment of state or local taxes assessed on the compensation of employees. And one question that I know came down the pipeline early on is about independent contractors and whether or not you can hire somebody who's an independent contractor as an employee for this period. And I know I have a section in here towards the end about independent contractors and what you need to know about them, but essentially I would absolutely not recommend it. Brooke, I don't know if you have other thoughts on that, but California has very, very strict requirements on who's an employee and who's an independent contractor. And mind you, there is no choice, right? There's no option on, well, the person wanted to be one versus the other. It's very fact specific, and we'll go through the ABC test later on, but I know that question came up. So the bottom line is no, absolutely not. Do not convert people from independent contractors to employees for this period. I think that the cost is way too great. And I know I love EO. I love all the entrepreneurs. That's why I choose to work with entrepreneurs, because they're so creative in coming up with new, bright ideas. But no, not for this. And I don't know, Brooke, if you wanted to say anything on that.
The only thing I have to say about that is, especially in California, they probably really are an employee and not a contractor.
Yeah. Yes. Yeah, if you have anyone who's questionable, they probably are, and then you need a whole host of other things, such as a release agreement and bring them on as a full-time employee, but don't make it because of the PPP program, essentially. Make it because of Dynamex, which came down 2 years ago, a California Supreme Court case. Make them an employee due to AB 5 that went into effect January 1st, those types of things. So, and then just a quick note on the employee compensation. So that excludes compensation for employees earning over 100,000. So that it's capped at 100,000. So if you have somebody, for instance, making 105,000 a year, they would obviously, you disregard that other 5,000 and it would be capped at 100. So, and then eligibility. So you're eligible for a loan if you are a small business that employs 500 employees or fewer, or if your business is in an industry that it has an employee-based size standard through the SBA that's higher than 500 employees, and that's how you hear about some big restaurant chains getting the funding and then sending it back. But that's another story. The CARES Act does not describe when the number of people or of employees should be identified for these purposes, but the SBA loan regulations look at the average number of employees in each pay period over the preceding 12 months. There will likely be additional guidance on how to calculate the number of employees, but it's based on, as my understanding, and Brooke, please jump in here again, but my understanding is that it's based on the employee headcount by full-time equivalent. So if you have 2 employees both working, 20 hours per week, that would equate to 1 full-time employee. So to calculate full-time equivalents, you take the number of part-time employees you have multiplied by the average of total part-time number of hours worked in a week and divide by 30. And the reason why you divide by 30 is because for these purposes, anyone working 30 hours or more is considered a full-time employee. I don't know if you want to say anything there, but and a couple other things, you have to be operational as of February 15th. So, we appreciate those businesses who are starting new businesses as of right now. Maybe you're going into the mask business or ventilator business or those types of things, but in order to qualify for the PPP loan, you had to have been operational as of February 15th. And then you have to have employees who are on payroll. We've gotten some interesting questions on this so far for business owners who may themselves not be on payroll, and our advice is to talk to your CPA or banker and probably switch yourselves onto payroll so that you can be included in part of the Paycheck Protection Loan Program. Let me see.
Can I say one thing about
yeah,
that?
Please.
Distributions do not count towards your PPP forgiveness. So
thank you, Brooke. That is very, very helpful. I did a webinar earlier this morning and someone was asking about that. So that makes perfect sense. And then another question I was getting, or I got that was forwarded to me beforehand, was whether or not people can ramp up employees to $100,000 salary annualized for a few payroll runs and then bring them back down after the 8-week period is closed. And Brooke, I'd love to hear your advice here, but the purpose of the PPP loan is to maintain headcount and salaries, right? Ramping someone up for a higher salary during a short period of time, I would just be super cautious about that. It makes me nervous, and I wouldn't necessarily recommend it, but Brooke, I'd love to hear your thoughts here too.
yeah, that's when we as CFOs kind of go, la, 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 I don't want
right?
to know. I don't think it's in the spirit of the law, which is kind of what you're saying. Like, it kind of gives you that slightly icky feeling. And there's going to be a lot of enforcement on these laws, on these loans. So you want to make sure that whatever you do, you could really defend if the SBA comes and audits that loan. The other thing is, and I think this is fascinating, it's kind of like people are getting these loans and acting like drunk sailors. I got to go spend all the money. You don't have to spend all the money. You can either give it back at the end if you don't spend it, or you can take a 1% loan, which is the cheapest money you'll ever see. But yeah, Cynthia, I've seen a lot of people that are like, I've got to spend the money, so I'm going to raise everybody up to $100,000. It's not the intent behind the law.
Yeah, and I agree with you. I think we're going to see people get audited for this type of thing. And then what? You're not going to be able to ask your employees, hey, give me that money back. That cost me 25 grand or whatever. So, I'd be cautious. So
I did read somewhere And I think it said that if you get $2 million out of the PPP, you 100% will be audited.
Oh, interesting. That's good to know.
You know, I don't know if anybody falls in that bucket, but.
No, it's good to know. I mean, yeah. Well, that, and then just going back real quick to independent contractors too, like I think if you try to manipulate the system and start hiring your independent contractors as employees, you are absolutely asking to be audited by EDD. So something else to keep in mind. I think we lost Brooke. Okay, so for the Paycheck Protection Loan Program, the loan is limited to the lesser of the right box or the left box. So the sum of the average monthly payroll cost times 2.5 plus any disaster loan taken out after January 31st, 2020 that has been refinanced into the Paycheck Protection Loan Program, or $10 million. So the term payroll cost is defined within the section to specifically not include compensation of an individual employee in excess of $100,000 as prorated for the covered period, taxes imposed or withheld, sick or family leave pay, or compensation for an employee whose principal place of residence is outside the U.S. And then we'll get into that. Someone says, thank you for the information. You're welcome. Okay, so for the, and as Brooke said, you know, the interest rate may not exceed 1%. This is the cheapest money you are going to get. So at the very least, if you applied for the loan and you got it, look at it as a 1% interest for 2 years. And all payments are deferred for 6 months. Interest at the 1% will continue to accrue over the deferment period, but it's that 1% interest rate. So the next portion of the PPP loan is to talk about forgiveness, right? So these loans may be eligible for forgiveness on a tax-free basis. Phenomenal. I think that's why we ran out of money in like 3 days. An eligible borrower for a covered loan guaranteed under the SBA is eligible for forgiveness of the SBA loan in an amount equal to the following costs incurred and payments made during the covered period, right? And that includes your payroll costs, including employee salaries up to $100,000, interest payments on covered mortgages, covered rent payments, and covered utility payments. And the covered period means the 8-week period beginning on the SBA loan origination date. Taxpayers should note that the covered period, as currently stated, is for 8 weeks and not defined to match the loan term. So if you'd like to use the PPP loan for other business-related expenses, I mean, you certainly can, but that portion of the loan will not be forgiven. And then unlike income from a discharge of indebtedness, generally amounts that are forgiven are not included in the borrower's taxable income. And like Brooke mentioned, the whole purpose and intent of the PPP is to help you retain your employees at their current base pay. If you keep all of your employees, the entirety of the loan will be forgiven. If you still lay off employees, the forgiveness will just be reduced by the percent decrease in the number of employees. So if your total payroll expenses on workers making less than $100,000 annually decreases by more than 25%, loan forgiveness will be reduced by that same amount. And then if you've already laid off some of your employees, you can still be forgiven for the full amount of your payroll costs if you hire your employees back by June 30th of 2020. The purpose of this provision is to encourage employers to rehire any employees who have already been laid off due to the COVID-19 crisis. Borrowers that rehire workers previously laid off will not be penalized for having a reduced payroll at the beginning period. And then, you know, there are other tax provisions that are included, and you should certainly be talking to your CPA about those provisions. So the percentage of laid off employees will impact the employer's forgiveness. And then that just goes over the 8-week covered period, and then, you know, that reduction. So to seek forgiveness, and I think that this is where a lot of audits might be coming up later on. You know, the borrower must submit the application with the documentation verifying the number of employees and pay rates, canceled checks showing mortgage, rent, utility payments, and then again, if you rehired June 30th, 2020, you will not be penalized. One of the questions that often come into play, and Brooke, I don't know if you have seen any guidance on this issue, is if you lay somebody off and then you go to rehire them and they're not available, if you can replace them with another employee with that same job title. And I believe you can, but Brooke, if you want to chime in.
Yeah, it's really, it's head count. They don't care who the head is.
Mm-hmm.
They just care that there's a head getting a paycheck and not getting unemployment.
Right.
If I can just ask a question there. So if the head count is the same as pre-COVID and let's say you rehire them on June 25th, as long as the head count matches or is above, then the forgiveness is in place around head count, correct?
Right, it's about head count.
Yeah, and you just have to bring them back before June 30th, but they don't have to be back for the whole term of the.
Right.
Yeah, okay.
Actually,
Brooke?
I've heard that it's the 8 weeks, and I got this from my own PPP closing docs. It's the average FTEs, the full-time equivalent during the 8-week period. So if you hire them back on the 25th, it's not just beginning head count and end count, it's the average FTE during the period.
Great, thanks, that's helpful.
So we have additional questions in the chats too. I don't know, Cindy, if you want me to read them for you or if you want to.
I'm trying to go through them now, but just real quick with the expenses that are covered, you can't prepay rent for the next year or anything like that to get it part of the loan forgiveness program. So keep that in mind. And then let's see. So someone's asking, if we decide to convert a contractor to an employee, is it possible to make them a variable comp employee after 8 weeks, i.e. hourly? So you're saying, so when you have independent contractors, and towards the end, we'll talk about who is actually an independent contractor and who's an employee. But if you have someone that you're considering converting for this, you probably should have converted them a long time ago, right? And so you're going to want them to sign a release for you. You're going to have to pay them for that actual release to be signed. And you have a whole host of other issues that are probably involved there. Because you can still be audited by EDD, even if the employee specifically is not going to make a claim. You can certainly bring them on to employee headcount, but then, and I'm not sure, you can bring them on as an hourly employee. But you probably should have done that a long time ago. So those are some thoughts there. And then we are going to get into internet expenses and phone expenses. I think that's a really important thing to mention, because if you have employees working from home, you want to reimburse them for those expenses. So make sure you're doing that. And then I'm not sure I understand this one. If payroll was $100,000 a month pre-COVID and now it's $60,000 due to layoffs, is it the number of employees or the total? Brooke, do you understand that question? I'm not sure.
Yeah, I think you're getting confused. The $100,000 and the percentage in your head count, those are two separate things. If you have an employee making $125,000 a year, you can't get forgiveness based on $125,000 salary. You can only get forgiveness based on $100,000 salary, and basically you have to eat the rest. So what's on here on the right-hand side of the screen is that you can't reduce your payroll amount by 25%. Is that what I'm reading, Cynthia?
Yes. So yeah. So if your total payroll expenses on workers making less than the $100,000 annually decreases by more than 25%, loan forgiveness is reduced by that same amount. That's what I'm meaning to convey here.
Yeah. So headcount is different. They don't care. So here's an interesting thing that I talked to, because I've been on a lot of EO calls recently, and like you said, Cindy, earlier, EO people get really creative. Was like,
I love it.
Wait a minute. I can fire the person in this job that's making $100,000 a year and hire somebody else in another job that's only making $25,000 a year. And yes, you can, because your FTE, your full-time equivalent headcount is going to stay the same. But where you'll run into is that 25% drop, I think. Is that right? Is that how you read it, Cindy?
Yeah, yeah.
So just for clarity for the other people on the call, if you're paying someone $125,000 a year, and you lower their salary to 100 so that you're completely forgiven, that's going to work against you in the forgiveness because you've lowered their salary?
No.
Okay.
No, it's capped at 100. So you only got a loan based off of that employee working at 100,000, even if you were paying them more than that.
Got it.
And then let's see, I have a couple other questions on this too that came out early on. Someone asked, we let go of an employee in February of this year unrelated to the effects of COVID, so our employee count is one less. Will this affect our forgiveness amount? And this is still about employee head count. The exact date of termination matters, as does the covered period for the employer. So, Brooke, I don't know if you have other thoughts on that.
So I missed the date of when they were let go, but
February.
It really goes back to what the head count was that you gave the bank when you applied.
Right, and you couldn't have applied in February for this loan, so theoretically you shouldn't have been able to count that person, so it shouldn't be one less, is my understanding.
Yeah, I think you're going to get dinged. But again, here's the thing. If you get dinged for having fired somebody and you don't get their salary forgiven, you also didn't have to pay them that salary. And at the end of the loan, you can either give the amount that's not forgiven back or take it as a 1% loan.
Right. Or, use that portion of the loan to pay rent and other expenses, right? That's what we can use a portion of the loan for. So it should not be a non-forgiven use, I guess, right? And then I have another question that comes up so often, unfortunately, is how to deal with an employee who does not have a great attitude, and during this time, they're awful, creating a toxic environment. And, lawyers will answer this question differently. And I know I hate to say this, but it's really up to the business. I really think that a toxic employee is detrimental to everybody involved. And if you do have a toxic employee, it's important to get them out as quickly and as easily as possible. If something egregious happens, like, and I've heard it, you have an employee who comes in, refuses to wear the protective gear, the mask, and is coughing on people, then, it's considered a terrorist attack. It could be considered a terrorist attack. And so if they're doing awful things like that, it's really important to get them out of your company, and probably not have them come back. So I would recommend terminating them. And even though it may affect your loan a little bit, you can still use that money to pay for other things like rent and interest on debt and things like that. So, and utilities. So I would still let the person go regardless. And okay, so moving right along to seek forgiveness, we just kind of went over that. So as you begin to bring employees back, or if your business has been able to remain open as part of the critical sector, or when the stay-at-home order is lifted in California, OSHA has promulgated guidelines which identify the employee risk categories. And this is really put in place to assist employers in determining what safety precautions are necessary for your workforce. I really recommend you check out OSHA.gov. It can be complicated, but there's a lot of information on that to help employers. So healthcare workers, healthcare support, these are considered high-risk categories. Your employees with high-frequency contact with the general public, such as school staff, those working in high-volume retail, those working in high population density workplaces constitute the medium level of exposure. And then employees with minimal occupational contact with the general public or co-workers, such as your office employees, your remote workers, those constitute the lower exposure risk group. So with regard to employee categories to assess risk and determine next step, those returning from affected areas, those in close contact with those returning from affected areas, those who've tested positive for COVID, and those showing signs or symptoms. So employees returning from affected areas, and I know there's been a lot of travel bans lately, but these employees will be required to self-quarantine for 14 days, may be required to undergo mandatory health screenings by federal, state, or local authorities. And then the employer can actually require a medical release to return to work for these employees. And you may want to maintain a high level of alert with regard to them. Employees in close contact, they may be required to self-quarantine, and then the employer may require a medical release to return to work as well for these employees. It's not really a matter of if an employee is going to test positive for COVID, it's really a matter of when, especially as we start to open up things. And you immediately want to send that employee home or have them remain at home. You can immediately treat the affected areas in which the employee worked as per CDC recommendations. You want to advise employees and our customers who were in close contact with the affected employee and offer a medical reimbursement expense for those employees. You do not want to identify the employee by name, however. That information is confidential, but you do want to give out workers' compensation paperwork if it's applicable, and let the carrier decide what's covered and what's not covered. Employees who are showing signs or symptoms, you can send an employee home upon observation of symptoms consistent with COVID-19. You can require them to give you a medical release to return back to work. Immediately treat the affected areas, and the CDC has very specific recommendations on how to do that. You can advise employees and or customers who were in contact with the affected employee. And again, it's important not to identify the employee by name. You can emphasize that there's been no diagnosis, but that you're acting in an abundance of caution. And so in order to assess the risk, you can ask your employees to inform you if they have come into contact with someone diagnosed with COVID-19, if they have symptoms of the virus or been diagnosed themselves, or of any recent travel to highly affected areas. You may not, however, target individual employees unless you have an objective basis for asking. And guys, we are to the point where we only represent the best-hearted business owners and entrepreneurs. And a lot of them, when this was coming down, decided to send only their 60-plus workforce home for the day. You can't do that. That's an age discrimination lawsuit. Think about this. You can't target specific employees. You have to have that objective basis and observe those symptoms. And then, of course, you can't ask about any other medical disability or medical condition. So keep that in mind. And then, there are some specific CDC recommendations for safety precautions. I'm going to just give you the website here because I'm starting to run out of time. I have a lot more to cover here. So check out cdc.gov, err on the side of caution. clean everything that's touched frequently, essentially. And then there's a general duty clause, which requires employers to furnish to each employee an employment and place of employment that is free from recognized hazards that are causing or likely to cause death or serious harm. And OSHA actually defines imminent danger to include any condition where someone can reasonably expect to cause death or serious physical harm. So keep that in mind. Recruiting new employees, I have a whole section on this, and I want to kind of get through it quickly, but there are many ways to advertise and recruit in your search for qualified candidates. You should avoid actions and language that could be interpreted as discriminatory or imply any long-term employment guarantees. I just had a business owner come to us who said that they used the word young in their ad. Oh boy, you don't want to do that. When advertising a position, consider whether it complies with all state and federal anti-discrimination laws and other laws related to hiring. You know, when drafting job posting, avoid language indicating limitations or exclusions on the basis of any protected status, race, color, national origin, anything like that. And then, a bona fide occupational qualification, that's the BFOQs, is a characteristic that employers are allowed to consider when making hiring decisions. So, for example, a religious school can require that teachers be members of the school's religion, but religion would not be a bona fide, occupational qualification for dentist office manager position. So, things like that. Criminal background checks. California law specifically restricts an employer's ability to use criminal background checks to make hiring decisions. Employers with 5 or more employees are prohibited from asking about criminal history on job applications or from inquiring about or considering criminal history at any time before a conditional job offer of employment has been made. There are some exceptions. Most people do not fall under them. But if you have, for instance, where someone has to carry a gun on them, then there's an exception. So like a security guard, something like that. And then checking references. There isn't specific law requiring that you check a candidate's references. Courts have always held that employers are liable for negligent hiring for certain acts of their employees, which the employer knew or should have known might occur. So reference checks are often part of the hiring process, but there are several things to look out for there. When checking references, if you intend to check a candidate's references, you should require the candidate to sign a waiver authorizing you to investigate all information that he or she submits on the job application. Employment applications should include a basic waiver allowing you to check past employment, personal references, education, those types of things. I can't even tell you how many times a client will come to us and say, oh, I hired a nurse, and then realize that they don't have the actual qualification. So it's important to check out those things. When contacting references, you must gain the maximum amount of information on a candidate without creating liability for invasion of privacy. So stick to questions that are directly related to job performance, including dates of employment. And then don't seek information about the applicant's salary history. That is now banned. You cannot inquire about or consider the conviction history of an applicant, of course, unless or until a conditional job offer of employment has been made. So kind of keep that in mind. Testing candidates. Testing's permitted. You can administer a variety of tests for some job candidates. When you administer tests, make sure that the test is job related and accurate predictors of success in the job for which the candidate is being considered. Employers may not implement tests that screen out or tend to screen out applicants with disabilities, unless, of course, the test is job related and consistent with the business necessity. And employers must reasonably accommodate disabled applicants during any testing process. And that includes making test sites accessible, using enlarged print, readers, Braille for the visually impaired, using voice recognition software, additional time, maybe things like that. Okay, so consistency, the biggest thing that I can say is keep consistency throughout to ensure that your interviews do not expose you to lawsuits, right? You want to create a list of appropriate questions, stick to them. You can ask all of the questions on your list or only those you feel that are particular to a job, and avoid overpromising. So you really want to protect the at-will relationship in California. Do not promise job security. An oral contract that is based on the conversations between you and your candidate could be just as binding as a written contract. So if litigation arises from an employment dispute, oral contracts have created problems in proving what the parties agreed to. So oral contracts are often created in job interviews where an applicant asks about job security. And a typical response from the interviewer says, you know, as long as you do a good job, you'll have a job. And that could create an oral contract. So keep that in mind. And then avoid any of these types of questions, right, that have to do with race, religion, any of the standard things. So you can reframe some questions, you know, asking someone, are you a US citizen, is inappropriate. You know, instead of asking, do you own a car, you can ask, do you have transportation to get to work, right? Instead of asking, are you a US citizen, if you're hired, can you verify eligibility to work in the United States, that sort of thing. Taking notes, I would not recommend writing on the candidate's application or resume. Do not use any abbreviations. Oh man, we had, for example, an employer made a notation on an application for a candidate for a position at the jewelry counter of a large department store. While he intended the notation to mean no experience selling jewelry, the words "no Jew" resulted in the candidate filing a religious discrimination charge against the store. So keep that in mind. Here are some common interviewing mistakes. Although there's no way to guarantee a candidate or employee won't sue, using a proactive approach is best. So, gosh, I'm really running out of time here. I have so much more to get to. So I'm trying to go fast. But what used to be a common check the box question on an employment application is now illegal. I hope everyone knows that by now. It's been in place for a few years. California joined several other states introducing ban the box laws to reduce barriers to applicants in the pre-hiring stage. And I don't know if anyone listened to the EO LA North talk yesterday, but it was a fabulous talk about a guy who was imprisoned for 18 years. And it just, you know, incredible story and experience. But the whole purpose behind that is to give people a second chance. So those types of things you want to not do. Another interviewing mistake is, you know, an innocent icebreaker question. Where were you born, or where are you from? Anything like that needs to be avoided. It could be based on discrimination. How much are you currently making? Absolutely not. You cannot ask this. You can ask, however, clarification came down that says that you can ask, you know, what are your salary expectations? So difference, make sure whoever is doing your interviewing in your company knows that difference. Questions about a candidate's age are prohibited under so many California laws and federal laws. Employers should stay away from questions that could reveal a candidate's age, like what year did you graduate high school? You may ask a candidate's age, however, if the job has a minimum age requirement. For example, if you run a bar and, you know, you're serving alcohol. Any questions related to parenthood or marital status are absolutely off limits. We had one company in Santa Monica, you know, the employee came in and said, I'm pregnant, and the CEO says, oh, well, do you know who the father is? those types of questions need to be avoided. He has a very sarcastic sense of humor, but that is not funny when you're in front of the jury. So even innocuous questions such as what does your spouse do should be avoided, as it could be seen as a roundabout way to getting to know the candidate's marital status. So it's okay to ask that type of a question though, once the person's been hired, but you want to stay away from that when interviewing. Okay, so the next topic I wanted to talk about, independent contractors versus an employee. And calling someone an independent contractor does not make them an independent contractor in the legal sense. These terms are defined by law, and you cannot circumvent them by agreeing otherwise with your workers. So there have been some major developments in the legal landscape with independent contractors. Beginning January 1st of 2020, AB 5 went into effect, which significantly altered the way California law distinguishes between employees and independent contractors. The new law follows the 2018 California Supreme Court decision in Dynamex, which was April 2 years ago, almost to the day. Dynamex set aside the long-standing common law classification standard that focused on an entity's control over the worker, and instead it adopted this rigid ABC test to distinguish an employee from an independent contractor. So let's go through that very quickly. California law is known to be one of the most rigorous in the country in terms of labor law. While both federal and state law apply to California employees, I really want to focus on California law. I know most people here on this call are based in California, but if you have employees in other states, I really recommend you check with local legal counsel prior to adopting or implementing a new handbook. We've had to represent a number of businesses who are headquartered outside of the state of California, and they hire one person in California to work for them, and it ends up costing them a lot of money because they don't do things per California standard. And California workers, if you have somebody working for you in California, they're entitled to the protections and rights that California has for the employees. So using an accurately classified independent contractor can, of course, relieve you of many burdens, which is why so many people want to have independent contractors. You don't need to cover them for workers' comp. You don't need to have employment taxes taken out. You have no rights to employee benefits and a whole host of other things. But there are significant risks. So in Dynamex, and I'm not going to go through the case, I guess, but essentially, the ABC test was adopted, and every single person has been having trouble with Part B of the test, right? That the worker performs work that is outside the usual course of the hirer's business. Most people are okay with applying A, that the worker is free from the control and direction of the hirer in connection with the work. Most people are fine with C, customarily engages in the trade involved in the performance. But B is really that area where people are getting stuck. So for instance, my example prior to AB 5 was I'm a law firm, I practice employment law, I hire an employment lawyer to work for me. That is the type of law I perform as services to my client. There's no way around that ABC test because I'm hiring someone in employment law to do the same type of work that I perform for my clients. That makes them an employee. And I'll have you note too that Dynamex automatically presumes that every single person that works for you is an employee. If you want to prove otherwise, you need to go through ABC of this test. So that's kind of the first step. And then AB 5 came out, and AB 5 went into effect in California in January of this year, where there are certain professionals, they are considered exempt if they meet certain criteria. And there's a whole host that goes behind each and every one of these. So I'm not going to go into it today, but kind of a lot to go through. But there are also specific exempt occupations. So now a lawyer or a law firm can certainly hire somebody as an independent contractor. But caveat that, let me talk about the business-to-business exception first. So the ABC test does not apply to a bona fide business-to-business contracting relationship if a business entity formed as a sole proprietorship, a partnership, an LLC contracts to provide services to another business. The Borrello test then determines employee or independent contractor status if contracting business can satisfy several criteria. And so I put that in here because you need to meet all 12 of these standards in order to have a bona fide business-to-business exemption under AB5. But so one, that the worker is free from the control and direction of the contracting business, that they provide services directly to the contracting business rather than to the clients or customers of the contracting business. You have to have an agreement in writing. Absolutely. And please do not pull one off the internet. Spend $1,000 with an attorney and have one done properly, because this will save you in the long run. Have the required business license or business tax registration if the work is performed in a jurisdiction that requires such a license. Maintain a business location that is separate from the contracting business's work location. Customarily be engaged in an independently established business of the same nature as that involved in the work performed. Actually contract with other businesses to provide the same or similar services and maintain a clientele, right? Advertise, hold themselves out to the public. I've seen people sue and they have their own website set up. They say I'm an independent contractor, and I've still had people sue for misclassification. So it's just one of the things that they look at. But under AB5, under this exemption, remember all 12 need to be met. And then negotiate on rates, equipment, hours, that sort of thing. So if all 12 criteria are met, then you go to the Borrello test. And that was in effect prior to Dynamex, which came out in 2018. So yeah. And then I'm just gonna skip kind of to, the Borrello test is based on the right to control. And these are the factors. In addition to the right to control, these are the factors that the courts will look at. And while the ABC test and the Borrello test overlap, the significant difference is that the Borrello test doesn't require a business to satisfy all of the factors. Rather, the courts consider and weigh the factors in each case, making it more flexible and less demanding than the very rigid ABC test. So best practice number 1, assume all workers are employees unless they clearly meet all legal requirements and pass all tests for proper classification. Run any independent contractor by your legal counsel. And then also best practice number 2, under certain circumstances, businesses and government entities who hire independent contractors must file reports with EDD. When hiring an independent contractor, the law requires a report from anyone who's doing business in California, deriving trade or business income from sources within California or otherwise subject to California law. So keep that in mind. Please make sure if you have an independent contractor that you are actually 1099ing them. Some people don't do that. And then just real quickly with regard to working remotely and working from home, I think it's really important to have a written agreement with your staff. You can say that this is only temporary, during the pandemic, although I don't know if I, suggest that, because who knows how long this is going to last. It's not like, okay, war's over, now we're all back to work. It could linger on for a period of time, but you can say maybe something like, while the California stay-at-home order is in place, this describes who's eligible to work from home and those not. Obviously, not all jobs can be performed off-site. It's important to lay out those expectations with your staff, your start time, your end time, those types of things. Adhere to the company's timekeeping systems, because I really think that we are opening the door for wage and hour violations in the coming months. You have your employees work from home, and they're going to say in 6 months, I was working 24 hours a day for you. And if you don't have timesheets in place and well-documented meal and rest periods, you're going to get hit with a class action lawsuit, or at the very least, a single plaintiff lawsuit. either way, you don't want to go there. It doesn't have to be anything fancy, but please track all-time work. I can't even tell you how strongly I feel about this. You know, I've worked in employment law firms since I was 17. I worked 8 years at an employment law firm, and I can't even tell you how many times I would come home and tell my dad, Dad, please track the time of your workers on an Excel spreadsheet or on a handout. No, 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 I don't need to do that. I like my culture. Well, then he was threatened with a lawsuit, and it got him to change. But me jumping up and down, screaming like, Dad, please do this, didn't happen. So yeah, please do that. And then reimbursable expenses. So when it comes to phone and internet, please reimburse those expenses. There is case law that specifically says that just because an employee already has the use of a cell phone doesn't mean the business can essentially get a windfall and use the employee's cell phone for business operational expenses and not reimburse that person. So